Outdated plans, unintended consequences. When a terminally ill father was unable to update his will, it set in motion financial turmoil and additional costs for the family left behind. So the client was a man in his 40s. He had come to us because his father had passed away. His father had terminal cancer and it was quite aggressive and it was a short period. And now that the father's passed away, we had to then work out what was going to happen with the assets. In this case, our client's father had an outdated will, which left the main asset, which was a family home, to the younger brother. And that wasn't the intention anymore because over time, it was agreed with the younger brother, the father, and our client that the younger brother will be paid some monies and will be looked after in other ways, and that it was agreed that family home was to be demolished. Our client was going to pay for the demolition, was going to pay and get a loan to build a duplex, and then once that was built, then our client was going to live in it and the father was going to live on the other side. And then when the father passes away, then that whole property will become our client's.
So what was the main challenge then that you had to overcome in this case?
Well, the main challenge was that the beneficiary under the will wasn't our client, it wasn't the intended beneficiary, and that was quite a challenge. And this was because the father's outdated will didn't reflect his intentions. And what this meant was, we had to work out how do we get this property into our client's name in the most efficient, effective way. And it was quite a challenge because the will doesn't reflect intentions. And so we went to a barrister, we got the barrister's opinion on certain things. We looked at another way of approach we can take, and which we applied to the Supreme Court with, and it was ultimately rejected, and that was to transfer the property to our client initially. And so because it was rejected and because we came to this roadblock, there was no other way other than for the property to be then passed to our client's younger brother and then passed to our client. And so what this meant was it was a $100,000 exercise, because when the property was passed under a will to a beneficiary as part of probate, as part of a transmission application, it is exempt from stamp duty, which is now called transfer duty. So that side to the young brother is exempt, but then when the young brother transfers the property to our client, there's no exemption. And so therefore our client has to pay stamp duty, which in this case was $100,000.
So he got possession of the property, but there was no way around paying the stamp duty.
Definitely. It was a partial victory, if you want to look at it that way. So we got the property in our client's hands, which was the most important thing and was the intention. But then the cost to do so was $100,000. And it's quite an expensive exercise because that $100,000 could have gone to school fees, holidays, a car, to renovation.
So I guess the key takeaway that I would have had from the story was that even though having those difficult discussions it's hard to have those discussions when someone's ill, that it's really important to have those discussions. What other key takeaways do you have for this?
This is definitely, Taylor, I think you touched on the best one, right? It's and I can completely empathize, and I understand it's a sensitive topic. It's sensitive. People don't want to have those conversations because, it can be shown as we're giving up on somebody. And, now we've got to talk about your will and how you leave the assets, right? But that's very true. And unfortunately, it is a very difficult conversation, but it's very important because without having those conversations, then it becomes a harder, lengthier, costly exercise for the beneficiaries in the long run. And so, like anything, the more you plan for something, the better the outcome is. And so without that planning, then it's really hard to dictate that outcome.